Hello and welcome to Simply inTAXicating. As promised, we bring you today more in-depth and technical analysis of budgetary changes in the Central Excise and Customs. The Finance Bill has proposed dozens of amendments and many of them are beneficial to the SSCs, such as the provision for revision of Central Excise returns, reduction in the number of returns, etc. etc. Let us go straight to Mr. Vijay Kumar in Hyderabad, who has 5 distinguished experts sharing their studied reaction to the proposed changes.
Welcome to Simply inTAXicating. I have with me Mr. Vijayanand. His JGM Finance in L&T Metro. They are building a huge metro in Hyderabad. I have with me the Dayan in this field, Mr. Thirumalai, who has been analyzing, commenting, understanding budgets for more than 40 years. I have with me Mr. Vineet Kapoor, he is Director of Finance in My Home Industries. I have here with me Mr. Suresh, he is Senior Director, Corporate Finance with Dr. Reddy's Laboratories. And I also have with me Mr. Raman, is Director Indirect Taxes in Grant Thornton. We will start with Mr. Thirumalai.
There are 4 specific issues where looking at the ease of doing business and also relating it to the fact that business has to be looked at as a total entity, end to end, in terms of the supply chain, particularly dealing with an indirect tax. What has happened is, to take a few examples, there have been elaborate changes on the customs side with respect to warehousing, starting from definition of a warehouse. There have been some provisions which have been omitted. For example, section 9 has been omitted. But there is also reference to this custom station in the Central Sales Tax Act. And therefore, what are the implications in terms of import-export trade, particularly those relating to sale made in the course of high sea sales or bond sales, which have been subject matter of litigation. This aspect should also have been looked into, because where necessary, there are already amendments that have been made in the proposed in the Central Sales Tax Act. We could have addressed this, because this is something which has been hanging fire for many years, and if we want to facilitate import-export, this is one area which must have been clearly addressed. The second one is with respect to the spectrum sales, which is going to be now treated as service and not intangible property or goods. And we have got the scheme introduced from 1/7/2012 on the service tax side with the negative list, where we have seen that several sections have been devoted to say how to distinguish between something which is deemed sale as distinct from a temporary transfer for purpose of service tax. This problem is going to add to that, because the VAT authorities are going to certainly say that this is also a transfer, a legal transfer, which must be subject to VAT implication. So, we are again getting back into this dual situation of tax, both VAT as well as service tax. Let me take the third example. There have been parallel notifications with regard to software on media, both where an RSP has to be marked and where RSP is not required to be marked. Already there are problems in respect of these resellers, where they are not only being subjected to VAT, but they will also be now be subjected to service tax in the context of information technology. And both the authorities are going to again get back to this situation. And I think one of the key things that should have been addressed is in terms of these overlap situations which we have been talking about. They have only increased and they have not reduced in terms of a resolution. The last point that I want to make is, while there is some dispute resolution process, I do not know, we will discuss that later, but in the context of the changes that have been made in Rule 6 on the CENVAT credit rules, which I think by themselves are very, very significant and welcome changes. But what happens to the past? If one sees the amount of litigation on CENVAT credit is very sizable, and all that they could have done is the mountain of show cause notices. Assessee could have been given an option to go and pick up those cases where he has been asked to pay 1,000 times of whatever credit he has been taken, and to settle those cases by saying, I will pay back the credit which I have taken there, let these show cause notices be dropped. That would have reduced litigation substantially in the context of Rule 6. And when we have done it for canals, when we have done it for dams, and when we have done it for public purpose buildings in the past, we could have also done it in the context of Rule 6, which I think would have reduced the wasteful litigation which this will carry in terms of the pending show cause notices which are there.
Thank you, sir. That's perhaps now it's supposed to be a government that listens. So perhaps the powers that be in the board or even the finance minister would listen to this kind of sage advice. But for certain areas, I think GST is the only solution. Mr. Vijayanand, what is your take on the budget?
Infrastructure, be it power, road, railways, or a port, or a bridge or a canal, they should be given equal impetus even in the indirect tax proposals also. But there has been a lot of hide and seek in the case of metro or monorail, and also the ports, airport. So earlier there was a lot of confusion whether railways includes metro rail or monorail, and subsequently it was clarified by way of a Magan notification exemption that metro rail is a separate category or monorail is a separate category, and it was a big sigh of relief. Then in 2015 again airports and ports have been removed from the Mega notification. Now monorail and metro rail has been removed from the exemption list. So this way there is a hide and seek. Whether it is a monorail or a metro rail or a airport or a port or a bridge, everything should be treated at par.
One welcome feature that has been announced in this budget is the facility to revise the excise returns. Now the central excise return has to be, if at all has to be revised, it has to be revised by the end of the month. What is the sanctity for this end of the month? Within those few days, will you find out the mistake? And what will happen if you find out the mistake just after a day of the closure of the month? What is your opinion on this?
I feel that the option to revise the return itself is a welcome step. Now there is a definite timeline for filing your return. And as an organization, I think generally is oriented towards compliance, and any inadvertent error that has crept in, people will have the option to revise. I feel if they are able to revise by end of this month, I think from the industry side, I think it won't be finding much difficulty. That's what I guess. But I think you cannot also keep it permanently open. Otherwise, once it gets cold, your attention goes off. So I feel, I think by month end, I feel it's doable. Probably we could have given some more time, but I think option to revise and till the window open till month end, I think it's fairly a welcome step. That's what I feel.
Let's take 1 month's return, for example. What actually goes into the return? Let's look at the opening balance, the credits that are accrued in the month, the debits that have gone away for the particular month, and there is a closing balance. Now, given a time period of 1 month, the revision is going to impact only for that particular month. Let's assume a period of 3 months have been granted for that. What technically happens is, not only that month's populated numbers gets revised, it has a ramification and repercussion for the subsequent months also, which means this 1 month's revision might result automatically in the revision of the subsequent month's opening balance and closing balance also. Therefore, probably at a prima facie basis, now that they've started giving certain amount of revision period, I would say it's a pretty welcome move.
There is another angle from which you can also look at it, where there is some relevance. There are multi-unit industries, where today, particularly because of the rural connections and the areas which are far-flung, they are not able to get the information by the 10th. In those cases, they are able to get it by the 15th or the 20th or the 21st, but not on 10th. Therefore, what is happening now is they are putting figures which are on an estimated basis, and therefore being visited with show cause notices saying that the actuals are different from what you have reported. At least those cases where it is not on account of any serious mistake, but on account of sheer impossibility of being able to collect and collate and present the information within the 10th for whatever reason, and this is happening in several areas, this at least will be arrested, and the show cause notices resulting on account of these will be arrested.
Fine, sir. Now, in fact, while on returns, they have also highlighted that they have reduced the number of returns. Now, won't it be easier if the excise returns periodicity is also enhanced? Like, instead of a monthly return, if you have a half yearly return like you have in service tax, won't it be a slightly better situation? What are they going to do with these monthly returns? Instead of monthly returns, why can't they have a half yearly return? Mr. Tirumala, what do you think on that?
No, you see, if you look at the excise side, the audit of ER1, a manual itself was published, if my memory serves me right, in 2011 or thereabouts, or even 2008, 8 or 11, between those two, and detailed checklists of how this has to be examined, and perhaps its linkage with the audit has also been fixed in some fashion or the other. Audit in the sense not only the inspection by the superior authority, but also, and unlike service where it is intangible, here the possibility of clandestine removal and the occasion for clandestine removal is therefore the closest point of time when you can get some hint out of the risk based assessment, because today the entire manual talks about that risk based assessment. I think to that extent, when companies are closing their books and there are exemptions for medium industries which have been provided, small and medium industries that have been provided, I think the larger units are one which we are talking about in this case, and since they are closing their accounts, they should not have, there may be difficulty in the far flung areas, and to that extent allowing the revision of return would be I think addressing this problem to a large extent. And I personally think that there is still a distinction between goods and services, as you said, until we get on to the GST.
So 1 month is okay. As you were saying on this different statutes requiring you to do different things, can't we ultimately think of one return for all government agencies, which can include your ER1, whatever statutory returns you have to file somewhere else? Is it possible?
I would say that would be ideal in all respects if you're able to get it, but considering that we have different laws, different statutes and different rules, I think getting it to one place will be very difficult as a process. I think that's something needs a giant step from the government. So I think that rather than being optimistic about that, we have to be just living in the current conditions. I think it's doable. I think like in a couple of European countries where they only have one regime, where there's only a GST regime, that's what is happening.
But under GST regime,
This is possible.
Now on that return, as he was saying, you file some return, then maybe rectify it at the end of the month. But filing a return ultimately results in perhaps a show cause notice. And for the show cause notice, the ticking starts from the date you file the return. Now there was always a confusion or dispute on the relevant date for issuing a show cause notice. In the good old times, the department had to issue a show cause notice within 6 months. Now they have made it 30 months for service tax. Now whenever normally this 5 years limitation is made use of, whenever they cannot issue a show cause notice within the 1 year that was prescribed. If they forget it in 1 year, they will somehow allege suppression or evasion and issue a show cause notice for 5 years. Now this actually, there has been a demand from the department. For the department, 1 year is too short a time. For the assessee, 5 years is too long a time. There is a Damocles sword hanging over my head for 5 years. Whatever I do today, I file a return. Until 5 years, I am not safe. So actually there was a strong demand in the tariff conference of principal commissioners and chief commissioners they held in Chandigarh last year, where many commissionerates requested the board to enhance or rather to do away with this different kinds of limitation. One limitation only 5 years. Whatever you do, the department has time for 5 years. Now, how do you look at this?
Yeah, I think from the industry's perspective, I think there is a state of suspense is being continued for longer duration. Given the fact that there are so many changes happening even in the industry, environment, etc., I think keeping the options open at the department to review the transactions and issue show cause notice for a longer duration will result in some amount of discomfort to the industry, and probably I think this one step is not towards the aspect of doing business, ease of doing business. So I think this could have been avoided.
The biggest vulnerable sector would be those taxpayers who would be paying service tax. 30 months and I may not even have taken a registration. 30 months, I may not have known that I'm liable to pay service tax at all. And even if I have registered, even if there is a service tax audit proceedings by the revenue authorities, let's say after 2 years, and they give me a clean sheet, as in there are no open paragraphs which they need to close, they come back again at the end of the, say, 2.5 years or close to 3 years, I'm subjected to the same level of vulnerability, as long as I'm there within the period of 30 months. This is not to say, as it was rightly pointed out little earlier, that revenue authorities do not really have a big time reasoning as to go for mens rea or invoking malified intent to slap a notice of 5 years in any case on me. So, am I really worse off? To a large extent, yes. Is this going to support the department? Not really, because whether it's going to be 1 year or up till the period of 5 years of limitation, wherever they found something in existence even beyond the 1 year period or 18 months in the case of service tax, they used to invoke the larger period in a slightly mechanical way. So I really see the status quo has not really been altered way so much by increase of 18 months to 30 months, other than leaving me a little more vulnerable even for a normal show cause notice.
Yes, sir. Mr. Tirumala, you have any view on this?
See, let us take two scenarios where how the investigation process takes place in respect of somebody who is registered filing returns and somebody who is not registered not filing returns because he was under a bona fide belief that he need not pay the taxes. In the second case, the investigation spreads right from day 1 to at least couple of years, recording of statements, etc. So, there are automatically the 5-year period is invoked in most of those cases where somebody has not been registered. It is those cases where somebody has registered filing returns in the knowledge of the department, and even they cannot dispute in any way that they were not aware of this. For example, when there is a Supreme Court judgment which has come, which now says that this is the law and they have to issue a notice based on that Supreme Court judgment, then clearly in those cases this 24 months or 18 months or 30 months will apply. But in other cases, I can't see how they will not invoke the 5-year period, because that gives them the right to levy equal penalty. And that is loss of revenue, and every show cause notice that is confirmed with 100% penalty, and there is nothing called right from cosmic die or any of those judgments in HMM. Nobody or even now later judgments like Uniworth, textiles, etc., nobody looks at those judgments at the first stage.
And one point is that in the case of with the option of revising the return, it gives the option for the assessee to probably to defend himself against the allegation of suppression and other things.
Exactly. So that's,
I think that's a positive feature. So to the extent,
positive or negative, sir, like what he was saying, in the first stage, suppression, intent to evade, collusion, everything is confirmed. Now, in the second stage of appeal, there is a possibility that you can plead, I have filed the return. There was no way that I knew that Supreme Court was going to give a judgment in 2016 when I am alleged to have evaded excise duty in 2013. They would say all that, like they have issued notices where the board has issued a notification and they have said you have suppressed this notification or you have suppressed that you are required to pay. So, at the second stage of appeal, maybe in the tribunal, there is every chance we can say, after all, I filed the return, I have informed them everything. They are in the know of things. In spite of that, they have invoked the larger period. Then the tribunal is most likely to give the assessee a benefit of demand of duty only within the normal period. Now this normal period gets extended. So to that extent, there is certainly a jeopardy. Yes. They have extended the period for issue of show cause notices by them for demand. There is no simultaneous or corresponding increase enhancement in the case of refunds. I am still required to file refunds within 1 year. And for any reason, if I am not able to file, there is no exemption for me, there is no condonation for me. Do you think it is unfair, or you think the refund period also should be increased?
we file a lot of refunds, and because since it's our money,
no one here.
Since it's our money, I think we go after them and see that we get it. I think your point is valid, that I think when there is a time for making a demand, I think assessee also should be given an option for claiming a refund for longer duration.
Another issue is, while this government was very magnanimous in giving in this budget, I think they have shown a little miserliness when it comes to demand of interest on finalization of provisional assessment. So on provisional assessment being finalized, whenever you pay the duty before the final assessment, during the period of provisional assessment, they say the interest has to be paid from day one. Is it fair, correct, or legal? What do you think, sir, Mr. Thirumalai?
No, this provisional assessment is now on account of the changes brought by notification 8 of 2016, non-tariff. They have substituted rule 7.4 and also given an illustration, which is what you have just now said. The question is whether it is right or wrong, because earlier the issues were what is the date of finalization, because that is how the rule was worded at that time. Having amended the rule now and also explained it with an illustration, say, and how interest will levy only on 1000 rupees and not on the entire 15,000 rupees in that example. The rule is clear. As of now, the rule is clear. On the question of equity and fairness is another aspect that we can.
No equity in taxation.
Yes. So therefore, as of now, if you a plain meaning of that of the substituted rule 7.4 would suggest that you have to pay, whether it meant going away from some of those judgments which had, including the SRF, which is now in a manner of speaking being reconsidered by the Supreme Court on a different perspective. But still, I think that as of now there is finality in terms of the substituted rule saying that you have to pay from the date when you ought to have paid.
I think so. What you rightly said was this is mainly to circumvent the loophole what we had, where people can intentionally also delay the payment of duties towards the assessment period. So that thing is the department has just basically plugged the loophole.
On this note, let me wrap up the first episode and thank all the 5 guests for sharing highly valuable feedback for the policymakers who may take note of certain comments like the issues relating to high sale and how the trading of a spectrum, which has been declared as a service, may invite the wrath of the VAT authorities and the demand for the option to file refund claim for a longer period. All the experts unanimously voiced their concern about the extension in the limitation period for issuing so-called notice, which may prove to be a potential irritant in the otherwise sincere steps being taken by the government to provide a tax-friendly, taxpayer-friendly tax administration. Thanking you all for watching TIOL.